One envelope, 60 days. That is what stands between a family and the loss of everything they mortgaged. Most borrowers do one of two things when this envelope arrives. Some panic and do nothing. Some reply, pouring out their whole story, and the bank answers with one line: "Your representation is rejected." Both make the same mistake. They don't realize that this envelope is not just a threat. It is the elephant's first legal obligation, and very often, its first misstep. Today, the demand notice, the 60 days, and the reply the bank is legally bound to consider, even when it pretends otherwise. Welcome back to Dr. Mind Forensics. Last Monday, we mapped the elephant's four arms. Today, we zoom into the very first step of the recovery machine, because if you understand this step, you understand the whole game. Under Sarfazi, once your account is classified as an NPA, the bank's first mandatory step is the Section 13(2) demand notice. 60 days to pay in full. But here is what most people never look at. The law doesn't just require the bank to send a notice. It requires the notice to say specific things correctly. The exact amount claimed, principal, interest, how it's computed. Details of the secured assets, the actual properties correctly described. The capacity in which you're addressed, borrower, guarantor, legal heir, sent to the right persons, every borrower, every guarantor. Actually served, not just dispatched into the void. Now watch how each line becomes a battleground. The amount. Banks routinely state figures the borrower has never seen reconciled. Sums that have swollen with penal interest. Charges compounded on charges. Sometimes double what was ever borrowed. In episode 4, we deal with valuation. But the inflation often starts here, in this envelope. The assets. You would be amazed how often notices describe the wrong survey number, the wrong extent of land, or property the borrower never mortgaged at all. The bank claims land it was never given. In law, there is an old Latin phrase for this: nemo dat quod non habet. No one can give what they do not have, and no bank can seize what it was never given. The persons. A firm where a partner has died, a mortgager who is no longer alive, a guarantor who was never notified. Each of these is not a technicality, each is a doorway, and we walk through them fully in episode 7. Now, the part of the law almost no borrower uses properly, Section 13(3)(a). This provision has a story. When Sarfazi was first enacted, the borrower had no right to object at this stage at all. When the Supreme Court examined the act in Mardia Chemicals in 2004, it insisted that fairness required the borrower to be heard, and Parliament inserted Section 13(3)(a). The borrower may make a representation or objection to the demand notice, and the bank must consider it, and if it rejects it, must communicate its reasons within 15 days. Now here is the pattern I want to burn into your memory, because it repeats in file after file across this country. The borrower writes a reply, sometimes emotional, sometimes detailed, and the bank sends back a single paragraph. Your representation has been examined and found devoid of merit. You are advised to repay the amount. No reference to your points, no engagement with the account statements, no answer to the wrong survey number, the disputed interest, the settlement offer you made. One line, a rubber stamp pretending to be a decision. A reply of that kind is not consideration. Courts have said, in judgment after judgment, that Section 13(3)(a) is mandatory, and that the reasons must show the bank actually applied its mind to what you raise. A rubber stamp is not an applied mind. And total silence, where the bank never replies at all and simply marches on to possession, is worse still. Here is the forensic point. The bank's one-line rejection is not just an insult. It is an exhibit. File it carefully. It will speak for you later, in a forum where rubber stamps are read very differently. One honest caution, because I will never oversell a remedy on this channel. The proviso to 13.3a says you cannot run to the tribunal merely because your representation was rejected. The defect matures into a full ground when the bank takes the next step, possession, sale. So the reply is not the battle. The reply is the ammunition. So how should the ant use these 60 days? Not with emotion, with structure. A forensic reply does 5 things. 1. Dispute the quantum, specifically. Not the amount is wrong, but reconcile the figure. Demand complete statements of every account from day 1. Question each charge, each penal rate, each debit you never authorized. Make the bank produce its own arithmetic. 2. Correct the record. Wrong property description, wrong extent, wrong capacity, a deceased party, a dissolved firm. Put every factual error on the record now, in writing, so the bank can never say it didn't know. 3. Assert your statutory shields. If the business is a registered MSME, say so, loudly, because a separate framework of mandatory revival steps exists before recovery, and banks skip it routinely. That is a full episode later in this series. 4. Put your settlement efforts on record. If you have offered a one-time settlement or the bank has ignored one, record it. A creditor who refuses to even respond to a genuine settlement, then rushes to auction, is painting its own portrait. And tribunals do look at that portrait. 5. Demand a reasoned reply. Quote Section 13.3a back to them. Ask in terms for reasons dealing with each point. Now the rubber stamp becomes impossible to defend. And whatever you write, send it so it can be proved. Registered post with acknowledgement. Email with delivery record. Because next week, you will see exactly how notices and replies have a strange habit of disappearing in transit, and how tracking records expose it. The elephant's strength is size. The ant's strength is that from this envelope onward, everything is on paper, and paper has a long memory. Remember Episode 1's rule. Tribunals discount indignation. They cannot discount an unserved notice. Today, add the second rule of this series. The bank's silence is your loudest evidence. A demand notice with wrong figures. A reply the bank never truly considered. A one-line rejection. Individually, they look small. Stacked together, they are the first cracks in the elephant's path. And the path, remember, is the only thing keeping the elephant's powers legal. Next Monday, Episode 3, The Vanishing Notice. How service disappears in the post. Why a notice can be returned before it was ever presented. And the 3-question RTI that exposes it. That episode is pure detective work. Do not miss it. If someone you know has just received a demand notice, share this video with them today. Their 60 days are already running. Subscribe, press the bell, see you Monday. Nothing in this video is legal advice, and nothing here is a comment on any pending matter. Consult a qualified advocate for your own case. Jai Hind.